today we are going over the Supreme Court of Ohio's new guidelines that they posted regarding parents living apart. And we are also going over, and I can't pronounce the county very well, but it's Tuscarawas County in Ohio. Their county courts adopted the guidelines, but put their own spin on it, I guess is how you would say it. So they made their rules governing parents' time with their children based off of the guidelines that their Supreme Court published, right? So that's what we want to go over today. We want to go over, how do all of you feel about these guidelines? Hopefully you read them. I did post them on my page. So if you did not have time to read them, go ahead and pull them up now. You can find those at our website on our blog. So that's fixedfamilycourts.com/blog, and that's plural, courts with an S, right? So a lot of parents are out there pushing for equal parenting, and Ohio's the first state that I actually have seen go this far, where the Ohio County Court, Tuscarawas, I know you guys are laughing at me, posted that if parents do not agree when their children are 3 to 13 years old, then the parenting plan that they will put in place is an equal parenting plan, right? So how do you guys feel about that? And I'm talking to the people who are fighting for equal parenting. Do you feel that it's great? It's giving you some reliability? I mean, that's how I kind of look at it. Ron and I, I'm Sherry Palmer, by the way, if you guys don't know. We are constitutional scholars. We study the case law to see how the case law interprets your constitutional rights and whether or not the trial courts are following that, which we do not find that most of those courts are following it. They are not. They are acting like super parents. Judges are. And we're going to go over with you today why that's not a good thing. Some of you may think that that's a benefit because you can go in and air your dirty laundry and perhaps get benefit. But the problem is there's no guarantee. So what we've been looking for is the guarantees that parents can depend on, and children, right? These cases affect children's rights. What can they depend on? So the Ohio courts, this one at least, this county court, Tuscarawas, Ohio, decided they're going to tell parents in advance what they can depend on. And why did they do this? Not just because the Supreme Court issued a guideline, because they said that's not the law. They don't have to follow their guidebook. It's because more and more parents, they say, are pro se, right? When I went over this with Ron yesterday, he, of course, was saying, well, he thinks, his thoughts are, that it's not just because they're pro se, it's because more of you guys are learning that your rights protect you from this unreliability, unpredictability, and you're arguing for your rights now. So you're going in there, you're pushing for something that they're not providing, and that is causing these judges to have to respond to that, to their unconstitutional practice, right? So if you're not conceding and you're not tricked anymore, now they got to follow the actual guidance from the constitutional guarantees, or I should say the guidance from the Constitution. They have to provide constitutional guarantees or explain why they don't like doing that. So what it looks like this court is doing to try to respond to that is, and it may not be just in their court, they could see this happening throughout the United States. So good job, all of you who are putting our rights topics into action in your states and putting this kind of pressure on the states. That's why they're updating their guidelines and rules. It's because of the pressure that you're putting on them. It's because you're educating yourself. So this court has said if parents don't agree, we're going to issue equal parenting plans. And if you want to see it, like I said, go to my blog and go to the bottom of the blog at fixedfamilycourts.com/blog. It's the blog, the most recent one I put up yesterday on Ohio equal parenting. And click on that link that goes to the county court. And if you go to page 3 of 8 on that rule, they call it Standard Parenting Order and Rules Governing Companionship Time. So if you cannot find my blog, put that into Google. Standard Parenting Order and Rules Governing Companionship Time for Tuscarawas County, Ohio. Okay. And go to page 3 of 8. At the very top, it says children aged 3 to 13. It says beginning at the age of 3, the parents shall share equal parenting time unless there are clearly defined special circumstances that would prevent them from doing so. Each parent is considered the residential parent when the child is with them, unless the court order states otherwise. If the parents cannot agree, the following schedule shall be followed. So several things there, okay? First, notice the words are shall, not we may, not we can. That's super important, right? Legally. And by the way, we're not attorneys, okay? And if I didn't say it, my name's Sherry Palmer. I'm with Fixed Family Courts. And Ron Palmer provided me with his feedback because he can't be here right now. He's doing some other work. But we looked at this and we read case law practically all day long, except for when we're dancing. So we've noticed, even though we're not trained attorneys, is that there's very specific words that courts will use, that the justices in the appellate courts will use, that the legislators will use in their laws, and those have significant meaning. So it will signal to a judge whether or not they have the option. Okay, now of course the judge has the power in their court. They can override things, and if they do, they just have to explain it. So if they overrode something like this, they'd have to give a pretty darn good reason. This is pretty much locks them in. They shall schedule this parenting plan if the parents do not agree. So two things, right? Is this encouraging parents to come to an agreement? The nice part is now, if you're a parent where the other parent's trying to attack you and take your rights, you no longer have to feel uncomfortable that as soon as you enter that courtroom, that all of a sudden you lose those rights. So you don't feel like in that bargaining room, if you're in mediation now, that you're starting at an uneven playing field, right? Which is a fear-driven response. If you're in a mediation and you feel like if you end up in the court, that judge is going to automatically be biased against you or take your rights right away, or you're going to have to pay a ton of money to have those rights, you might make agreements that you otherwise wouldn't make. So now you've got an even playing field, sort of. And the reason I say sort of is I'm going to go over that in a minute, is that special circumstances word, right? And the fact that nowhere in these guides do they say, and I'm talking the Supreme Court guide and also these guidelines and rules from this county court, nowhere does it say that they have to follow the supreme law of the land. Now they do, but they're still trying to ignore it. So that's a risk factor for you, and keep that in mind. Is what that means is you still need to make sure that you keep constitutional language, your rights language, in whatever you do, your pleadings, when you make orders, make sure that they're enforceable, make sure that you're preserving error, okay? So don't just rely on these plans. So when you're in negotiations before court, right, if you're trying to avoid having to end up in court in the hearing now, and most courts require mediation, you now don't have to feel like you cannot push the other side to, how do I want to put that? You don't have to feel like they're just going to steal your rights as soon as you don't agree with them. Okay? So you can actually hold your ground. That's super important. That's important for your child. That's important for you. Now, we've got some comments from some people where they didn't like this, actually. And I agree with whoever made that statement that this guide is a light security blanket. That's true. It's much better starting point than you had before, though, right? So just the fact that they're recognizing that this is the starting point is huge. It really is huge. So let's start with some comments that, like I said, if customer service can get on here. I see Curtis, you put a comment. You think the whole country needs to change for our children and the future of our country. Can't see the whole thing because of this other comment here. Okay. Children need their fathers. And I'm just kind of skimming through it real quick. Curtis, your finances were taken away. Due probably, yep. That's a big problem, Curtis, and that's why I'm liking them starting from this point, because if you didn't have to have the stress of worrying that you had to fight to get to the equal, wouldn't it have been less expensive to begin with, right? Maybe the other side wouldn't automatically assume that all they had to do was hold out and deny you. As most of the courts, what they've been doing is, oh, well, the other parent doesn't want it, so, you know, we can't go with that. That's been the problem. And if your state has a standard possession order like ours where it's actually minimum time instead of maximum time, that's a problem, because they've just been issuing one parent the minimum time, the other parent gets the maximum, just because the two didn't agree that both parents should spend more time with the children. So that's a problem. Hi Trish, I see you on there. Howdy back. Rob, I agree. I wish more counties would start doing this. It looks like you said you're in Claremont County. Is that in Ohio? Because if you're in Ohio, Rob, just take this Supreme Court Ohio guide over to the administration of your county court and ask them, and take the one from Tuscarawas as well, and ask them to adopt it as their rules as well. And Monica, thanks for showing up. And okay, so you're the one who said it's a light security blanket, but not a substitute for asserting your rights in words and in writing. Very true. And Adam, hi Adam. I know you go on CJ's feed a lot. I haven't had the pleasure, so welcome. Thank you for showing up. And your comment, let me back this up here. Your comment is, in order to hold them accountable to the law, learn, know the law, speak and assert it to the judge. Okay, so that's true. That's true to a very large extent, Adam. It's the way you speak it to the judge. Those judges have massive power in the courtrooms, so if you offend them, they can punish you, and your punishment, unfortunately, punishes your child. So it's a very delicate thing to do when they have all that power. So you want to make sure that you're doing it in ways that are less inflammatory to the judge. So absolutely true. Assert it to the judge so that it is clear on the record that you're not conceding. So if they are defining, we're going to get to the next part here, define special circumstances, right? So is this an empty promise, this equal parenting plan? Are they making it moot when they put special circumstances on there? Are they just saying they're going to use best interest? So now here's where we get the insecurity added back in here again, and your costs going up, right? Because anything in litigation, when there's insecurity, unpredictability, that means you're going to have to pay more money to protect that right. Okay, first of all, they're not recognizing this as a right. They are seeing this as what they're calling parenting time. That doesn't mean that they're saying this is a constitutional right. So what happens here is they could insert as special circumstances best interest, right? That's very dangerous for you who want to be able to make decisions that perhaps are not favorable to the judge, because you're opened up to bias when the judge starts using best interest. right? They say they're looking out for the best interest of your child, but we've seen a lot of errors occur by only applying that policy. You need to insist that they apply some kind of risk reducing or error reducing test, right? I'll give you an example. If you're trying to introduce an expert witness so that you can counter some other testimony of another expert witness, this actually happened in a case that I read, and the judge is trying to evaluate whether or not that expert should be allowed to testify against the other expert when maybe they didn't perform the evaluation or the study that produced that report that you might be trying to challenge, right? So let me put that in easier terms. Let's say you're in a hearing and you've got a child custody evaluator who wasn't favorable to you. So they have testified that you should not have equal time with your child, that they should keep it with the other parent, or maybe they're testifying that they should flip custody to the other parent. Maybe you have primary and you want to challenge that investigation and that report. Well, so you might bring your own expert in. And the court, the other side might be opposing your expert, of course. They don't want their testimony countered with anything that the court would apply more weight to, because your own testimony about it doesn't get as much weight as another expert. And I know I'm introducing a lot of concepts, so if you don't understand these concepts, I encourage you to become a member of our online program, where we have an online course, and we're going to be introducing more videos every month in there, as many as we possibly can. For $20 a month, you can get in, start learning more about these concepts. Again, from a layman's view, we are not attorneys, okay? So please, anything you learn from this, run it by an attorney, even if you don't have one, and make sure before you use anything, you absolutely understand how that's going to be used legally as a term, not how you understand it in English terms. That doesn't mean a crock in courts, right? The way the court interprets it. You don't know how, you can go to scholargoogle.com. If you don't know how they're going to use that, look it up in cases and see how they interpret it. Okay, there's a little bit of trick to that too, and like I said, we'll be sharing videos in that site to help you understand that as well. Like, how are they, how do you apply that term to your situation in your case is an evaluation process. All right, so we'll be putting that in there. But anyways, let's get back to you're trying to counter that other expert witness's report. So you're trying to introduce an expert, and the judge is trying to determine whether or not they should be introduced. So they might use something, let's just pull something out of the hat. Let's say they say, oh, well, I'm going to apply the Daubert's test, right? You guys can look that up. That's D-A-U-B-E-R-T. One judge actually did this. I'm not going to say whether it's right or wrong that they should have applied this particular test for this situation. I'm not a lawyer, so you'd have to check with a lawyer on that. But that's what this judge decided to use. Why did this judge look for something to use before determining whether or not that expert should be allowed to testify? He was trying to reduce error. So in other words, if he was wrong and gave the wrong, if he didn't allow the expert to testify and didn't have any way to support it, then maybe he could get overturned on appeal, right? And thank you for whoever listed Daubert on there. I'm going to guess it was Monica. So thanks, you guys, for doing that. If the judge is using a test to determine whether or not they should make a certain decision so that they're reducing the risk of error on that decision, don't you think your child deserves the same protection, right? And that would mean it shouldn't be unreasonable for you to ask the judge to provide a test regarding whether or not, or regarding what process the judge will use for determining when the court gets to interfere with your rights to your child. Would that be unreasonable? I don't think it should be. And in fact, we've read case law that says parental rights are fundamental rights, and you guys have probably seen those cases, Troxel, Stanley, look them up. They're all over the internet now. They're all over scholar.google. If those are fundamental rights, and the judge is applying just things like public policies, state policies like best interest, that's very risky. There are lots of error that is produced from that. So ask for a Matthews test. That's what I'm proposing here. Ask for a Matthews test. And if you want to understand that further, get into our membership. I don't have time to go over that today. So that's the point I wanted to make today about the special circumstances section is, are they making this equal parenting plan moot? Because if the other parent just goes in and says, well, apply these factors before determining whether or not this parent should have equal parenting, then you can't count on the words at the end of that paragraph on this page of this rule for these courts. If the parents cannot agree the following schedule shall be followed, you cannot depend on that. Okay, so what I'm telling you is walk through these things like you would a math problem. Show your work like you would want the court to show it. And that means once you really get down to it and you're finally done with figuring out this math problem, are they really providing you with the security of equal parenting? I'd say probably not. Okay? Probably not. And the only way you're going to correct this and cure this, again, is getting those rights in there. If you want to be able to argue on appeal that they messed up by not giving you this plan because they said shall, because that's all you're looking at, you're not going to be successful if you didn't protect your rights. Okay? It's going to be very disappointing to you, so don't make that mistake, okay? So let's see what else others are saying. 6 years of trying to rectify custody order and still wasn't even able to get 50-50 rights in Georgia. Yeah, that's sorry to hear that, Nick. That is happening all over the country, and that's why it's so important that you do frame your case differently so you don't have to keep going back for modification after modification. You got to go at this straight up. First time, you got to go at this by saying, I don't concede to this, and here's my rights, here's what I want you to apply, and you've got to object any time that they're deciding to apply these lowered standards. And lowered standards is preponderance. Applying special circumstances that aren't being applied under a proper adjudicative hearing, that aren't using clear and convincing evidence. Now, your statutes are going to say different. Your statutes are going to say they can use preponderance, they can use best interest. So you're going to have to get an attorney who's very skilled at this, or learn this yourself, how to present this to the court in a way that you can uphold on appeal. You can't just go in and make it up, by the way, you guys. You can't just go in and say, hey, I said it. I have rights. Now I'm going to appeal you, and I'm going to get you overturned on appeal. It's not going to happen that way at all. If the law was that simple, these lawyers would not have to go to school for multiple years, pay hundreds, thousands of dollars. Some of them pay $200,000 to get this degree. That's because this is technical. English language is complicated. Okay, don't blow that off. Again, don't just apply your own meaning. Okay, well, I'm going to look on another page here real quick, guys, because I want to make sure that I go over some of the comments that we were seeing posted about the equal parenting, and it's very interesting. The responses that I saw up there were concerns about equal parenting not being one, fair to the children, and I'm not sure. I know most of you guys are going off of your own personal experience or maybe a friend's experience in this, but really think about this. Is it fair to the children to not know if they're going to lose a parent when it's not their divorce, right? Is it fair to the children to have to go years and years of being unsure of which parent they're going to be restricted to as a visitor instead of them being a full parent in their life? Is it fair to take away that development? Okay, so you may not like that other parent anymore, and you may not agree with their choices, but you know what? That's their child too. So I'd like you to reevaluate where you're coming from when you make that comment about it not being fair to the child. Okay, so I'm going to look on here. Okay, so I'm going to go to fixedfamilycourts.com/blog, and if you go to the bottom of it, you'll see the comment that I'm going to be reading. So if you're one that is also visual and not auditory, and you want to follow along with me, go to the blog page, scroll down. Oh, it looks like we have more comments on here now. I only saw Anna's comment yesterday, and hers was, equal parenting is great if both parents are equally fit within reason, and there is no doubt that there is not abuse of any kind that would threaten the well-being of the child, especially children of the ages of 3 to 7. She says they're vulnerable and they have little recourse to protect themselves from a parent. In all appearances, that parent might seem to be fit, but may not be, and so she thinks the law is flawed. And she says it's flawed in the ability of the court to learn the truth of whether or not a parent is fit to have primary care of the child, especially one as young as 3 and 4, and it's limited and short-sighted. And she says if both parents are fit, they should be able to communicate with each other in a civil manner, always in order to maintain continuity of care, and especially for those who are 3 and 4 and up to the age of 7. And she says if the parents are socially and emotionally incapable of dialoguing with each other, that's an important factor, and that factor should not be dismissed. So I'm going to have to say that there are several things that I'd like Anna to reevaluate here. One is, where is she getting that parents need to qualify just because they're living apart? So all of a sudden they need to qualify for custody of their child. That is not the way our rights in this country were actually supposed to work. That is something that the courts have created out of their own cloth, right? They have not had any constitutional grounds that I can find, no constitutional justification for making parents who are living apart qualify to have their rights protected to their child, which is what protects that child. So even if the child's a baby, Anna, the other parent is a parent. You guys chose to have a baby together, or whether it be accident or not, what makes you more entitled, and I'm not saying just you, and I'm not meaning to be offensive, but I'm just saying a lot of times I do hear it come from moms. I hear it come from dads where moms have taken off and left the child with them. That's a different scenario. Okay, a parent being absent intentionally or on their own, of their own volition, different topic, okay? But let's say you're both parents. But what I hear is that a lot of times, because the mom birthed the child, they naturally have possession, so they automatically feel like they are the one who will be protective and that the other parent won't. And I'm not really sure where you're getting that from, because they could look at you and say, you didn't have any experience the first time you had a child either. You had to learn it. So let that other parent learn it. That child has a right for the other parent, even the mistakes of the other parent. That child has a right to learn from that parent, mistakes and all, flaws and all. So I would have to disagree that the child shouldn't be with that other parent. And when you're saying that they don't have an ability to protect themselves from 3 to 7 years old, I found that as a problematic view when I went through it. It was actually very abusive feeling to me from the courts to be saying that they were protecting the children from their parents. That was a very foreign concept to me then, and very hurtful, very destructive actually. So I'd ask you to reevaluate your view on that, and before you say that the children are vulnerable and have little recourse to protect themselves, think about who you're saying you're protecting them from. If you're saying you're protecting them from the other parent, then why wouldn't that same premise be applied to you? And why would you want to go through that kind of evaluation process? You're not going to be perfect either. And like I said, I'm not beating you up personally. I'm speaking in general, okay? I'm just responding to your comment. That why would you think that it's okay or that the court is authorized to come into your private business like that. They shouldn't be trying to protect children from their parents. Now, when it comes to the question of fitness, you should not be questioning a parent's fitness unless they have violated child protection laws, child abuse laws. So my question would be to you, why do you think different standards should apply to parents living apart? Right? And the last thing, Anna, on your comment is that you think that parents should have to be able to communicate with each other in a civil manner. Now, I would say civil manner, that's nice, that's preferable, but if they decide they don't like each other, they're probably not going to communicate with each other in a nice manner, if that's what you mean. Like, they may not agree. Let's put it that way. Now, if they're being abusive and they're violating the law, that's different. You can get restrictions placed on, you can try to have charges brought if somebody's being abusive, violating the law. I don't like, just so you know, where I'm coming from and where this feedback is coming from, for full disclosure, I do not like most standing orders in states that place prior restraints on parents' communications or any kind of gag orders. I do not like those. Those are unconstitutional. When I say do not like, what I'm saying, not personal opinion, I'm saying from a constitutional viewpoint, is that constitutionally speaking, you are guaranteed to have the right to communicate in the way that you choose. Now, if there's a law that states what the way you communicate is illegal, then you may just face consequences. I don't like this future looking type of order that says I'm going to put in an order that almost makes the assumption you've already violated, so I'm going to put the penalty in there, right? That's not okay. Okay, that constitutionally, that is not okay. That is called a prior restraint or gag order when they tell parents they can't communicate certain things. If somebody's going to abuse their right to speak, and they're going to do it in a manner that is not conducive to the other side agreeing, but they're going to be abusive in it and it violates a law, then, like I said, bring charges. But if they're going to communicate in a way that just is disagreeable with the other side, and they're not going to be, depending on how you're defining as civil, if you're meaning be nice to the other parent, well, you know what? That's their choice. If they don't want to be nice, maybe then they don't get agreement, right? But not agreeing in itself for many of the circumstances, meaning whether or not the other side gets equal time, is it should not be grounds for the parent having less time, right? So I know a lot of courts use it. In fact, Monica, that happened in your circumstance. You know, they're looking at you as a high conflict parent and taking away, I'm going to say, your child's rights to be with you, okay? Because there are some people complaining, we're just looking at, a lot of people are looking at parental rights, not child's rights. Those are the children's rights. So you protecting your right is protecting that child. So again, you guys need to review how you're looking at this, because you might be starting from the wrong basis or foundation. So I would have to say, Anna, not getting along, evaluating people on their social and emotional capability to dialogue is not allowed constitutionally. I would say that's not an important factor. If people want to communicate and get along, they will. Part of the reason you guys aren't together anymore and your parents living apart is because you don't get along, because you might not have that capability. But you know what? They may not have had that capability when you guys had the child together. So why would you hold them to different standards? That would be the bottom line for me on your comment. Let's go to the next one. And we've got, quickly here, the first one was from Brandy. And her comment was, they can still have access to both parents without moving homes and disrupting their routines every other week. And she said, if one home provides more love, support, and stability for them, why can't they stay there? Why do they have to leave that home? And although the second parent does love them, maybe they don't have family around. They may work a lot, leave the child alone or with a babysitter the majority of the time. They may have their own rooms and own space with their favorite toys at one house, not the other. I'm not going to read her whole comment. I'm just giving you some of the questions. And she says, everything should be taken by case basis and thoroughly researched. Every family dynamic, she says, is very different and intricate, needs to be thought of before making decisions that affect these kids' futures like this. Okay, so Brandy, I'm going to give you a little bit of the same feedback I gave Anna, and then I'll address more of what you're asking. And some of that feedback is, I'd like you to reevaluate where you're starting from. To say that they need to evaluate each home, to say that the homes need to provide more than the basic necessities, I would say is not a constitutional. That's not the foundation that you start with for a constitutional evaluation. The foundation you start with is the child being provided with their basic needs from both homes, and that would be food, clothing, a roof over their head, not who has the nicer bed, whether or not the child sleeps on the couch at one home or the other. You're stating that some instances the child sleeps on the floor. I know some kids that prefer air mattresses or their sleeping bag on the floor, so who knows if they're sleeping on the floor because they want to or not, or maybe the other parent's in transition. If you're saying they don't have basic needs, they don't have their blanket and their pillow, or you know, that they're not getting basic needs, and I'd say, you know, basic sleeping area would be basic needs. So you might have a complaint if they're on the floor because there is nowhere else for them to go. But I hesitate a little bit. I'd say, okay, that might be the beginning of some kind of complaint, but look at your child abuse laws. Would that qualify? Okay, if that would qualify and apply to everybody. The reason I'm hesitating is, would a married parent have their child taken away because the child's sleeping on the floor? Why is that? So there may be some details there, but also remember, before you start invading the privacy of a parent's home, you've got to have some kind of proper cause of action. I know the family courts allow it, so remember, we're not speaking in terms of what the statutes are going to let you do. They're going to let you guys fight over every little one of these details. But we're trying to start thinking about this differently so those fights will stop, because fights are very damaging to your child. It looks like the feed had been lost for a brief moment, but we're back. So what I'm saying is, before you start using things against the other parent that maybe wouldn't be used against them in a marriage, make sure that it's something that is going to qualify under a child abuse standard and not just under the policy of the state. Because you know what? I've seen a lot of parents who call themselves protective parents have the courts flip on them because they go in there and they insist that this is bad or damaging for their child. But what ends up happening is the courts look at what's more damaging to them. Is it more damaging them to sleep in a less preferable place, or to lose a parent? Like you said, that parent may love them, so maybe they're poor. And last time I looked, you weren't really allowed to take a child away from somebody who's poor. It only seems to happen in these cases, in divorce, or cases where someone's establishing their parentage, their paternity, right? I only seem to see it used there, and I would have to say that if they fought that properly, that it's not going to stand up for that court, because they're taking their child away from them based on poverty. Okay, so the other thing that you're stating is, why can't a child stay in a home that provides, you're saying, more love, support, and stability? Okay, that is asking the judge to be a super parent, right? What is he using to evaluate more love? How do you define that in the law? More love, support, and stability. What is that required to be a parent? Maybe one parent defines it one way, and the other parent may define love as restricting their child from certain things. So I would have to say that that's too that's not a reasonable thing to have the court review, because that's going to continue and perpetuate this unpredictability. And unpredictability in our courts is bad. It's bad for your children. It's bad for society. So I would say that's the wrong or that's not the proper way that I would want to present something to a court if I were you. It leaves them very much in control. And if you want to have control over what your life is going to be like in the future and your child's, you probably don't want to put some kind of question in front of them that's going to require them to use their own beliefs and their own prejudices and apply their own definition to something. So why can't they stay in that home, just that home, Brandy? Is because that is more detrimental to the child than being with a parent, the other parent, regardless of their flaws. And if you need more studies and information on that, we have other blogs that talk about that. You can research on Google. They'll talk about the detrimental effects of soul parenting. I don't like to apply it to whether it's the mom or the dad damaging the child. I think it's the soul parenting. Does that mean a soul parent can't raise a very healthy, effective child? No, that doesn't mean that, because some parents pass away. So it's rude, in my opinion, to think or state that a soul parent raising a child is what the problem is. The problem is when a parent is made a soul parent and another parent who is adequate has been cut out of that child's life. That child doesn't understand that, and they are being deprived of the other parent's flaws, if you want to put it that way. But I'm sorry, but life is made of flaws, okay? Some flaws end up resulting in beautiful things. Some mistakes end up resulting in beautiful things. So putting your own judgment on it is a problem. That's why I like constitutional foundation and guarantees. And that's why I like tests that lower the error of these risks. It doesn't leave room for more love or support for the law to decide that one parent's love or support is better than the other one's. Okay, so I would have to disagree with that kind of question being put in front of a judge. So they can't stay in just one home. They don't stay in just one school. They don't stay with just one teacher. When you put them in different activities, they get different sets of rules. So please reevaluate what you think is harmful or damaging to your child. Having differences in people's lives and different sets of rules, different homes. I raised my children that way. They are happy, healthy, productive children. It's not the kind of damaging effect that you may think. Some children are a little more sensitive than others, so there may be some special things for special needs kids that you may need to do, but other than that, even special needs kids can deal with some stresses, right? There are stresses in life. Without them, you're going to curl up in a corner if you don't know how to deal with some of them. So you do have to balance and manage, just like we're asking you to balance the way you view these things. You're asking the court to balance the way they are treating fundamental rights. Okay, so it's all about taking the emotions out of it a little bit and getting a predictable foundation in place. And then you know what? You may find too that other parent may start being more workable when the threat is removed. We find that a lot, that sometimes people are just being bullies to each other and really more combative when they think they can get a court to side with them. It becomes like a competition, and the court starts to use that when in actuality, it's the process. It's the adversarial system that's really caused a lot of that problem. Okay, so I'm going to go to the next question, and we're going to have to finish up because it looks like we're kind of out of time. I think we're out of time, so I can't address any more today. I apologize. I hope that this helps everyone who's expressing concern about these equal provisions that are starting to make headway and starting to make progress. We, from a constitutional perspective, are very happy that judges are starting to recognize in Ohio that there is the necessity to provide some more predictability for the children and for the parents. I think they're going to see a lot less conflict if they do one more additional thing. That is, take that special circumstances and define it in a constitutional way. That would be my recommendation for anyone in Ohio who is continuing. Don't drop it here with your Supreme Court of Ohio or with your legislators. Go back to them and say there's going to be some issues. We need some clarifications here. And when you provide clarifications, provide them with constitutional protections. That is how you're going to protect your child. That is how you're going to protect your dreams, their dreams, your resources, and how you're going to be able to move forward in life and move beyond this divorce, beyond the fact that two of you are living apart, and put your focus back on developing your child. So I wish you all the best, and I hope that this helps, and I look forward to more states moving in the right direction like this one. And thanks guys so much for joining me today. Now I'm gonna have to run, but I really do appreciate all of you. Thank you so much. Bye, talk to you later.